Hello friends, today's lecture will be on the legal skills for the students of ICSI, and today we will be covering in our topic following basic legal documents like how to draft agreements, what to keep in mind, the legal principles, memorandum of understanding, affidavits, difference between notary and oath commissioner, attestations, power of attorney, and difference between petition, applications, writ petition, rejoinder, and pleadings. So let us begin our topic with the first topic, subtopic, that is agreements. The topic agreements, when we discuss, it relates to different kinds of commercial agreements which as a professional you will come across. It will be like example like lease deed, partnership deed, and various kinds of deeds will come while you are performing your professional duties as a company secretary. So all you should keep in mind before drafting an agreement, before vetting an agreement, or before analyzing or reviewing the agreement, certain basic principles of the contract law, because agreement is a term misnomer in the sense any agreement which is not enforceable at law will not be an agreement recognized in a court of law. So it is a contract in principle, which when we say that we are talking about an agreement. So MOUs, the another topic which we'll be covering a little bit later, that also falls in the realm of agreements, because any kind of document can be loosely termed as agreement, so nomenclature may differ. So before going further, so we'll be practically discussing the major principles of contract law which one should keep in mind while drafting, reviewing the agreements, including MOUs. So first is the scope of the contract law. Contract law gives freedom to the parties to enter into the contract as per their express terms and conditions, which we called as intention of the parties. So contracting parties can frame the details of the contract while remaining within the overall four corners of the contract law, because parties cannot agree on anything and everything. So the agreement between the parties must conform to the basic principles enshrined under the Contract Act. That is why there is a maxim that parties to the contract make the law for themselves when we are drafting the agreement. It provides for different kinds of rules like how to form the contracts, how which agreements cannot be entered at all, for example void agreements, and how the contracts have to be performed, what are the remedies in case of breach of contract. But we will not be going into the other aspects. What we'll be covering is that the topics which are relevant to the drafting of the agreement, for the review of the agreement, we'll be touching upon those principles which are very, very practical, which one should keep in mind. Otherwise there are the consequences which the parties face is that they end up going to the litigation, because terms and conditions are not as per the law, and anything which is against the law cannot be sustained in a court of law. So ideally speaking, what the contract law deals with, it deals with different kinds of contract. Like there can be an indemnity contract that is promised to make good the loss of another, such as insurance companies. Then there can be contract of a guarantee contract, that is an undertaking to pay or perform the promise of another. There can be contracts of bailment, which is nothing. It is in terms we can say that it's a temporary delivery or possession of goods to another for a specific purpose. And then there are documents which we call agreements relating to pledge, that is bailment of goods as security against any loan. And then there are contracts of agency, principal and agent relationship. So then we have contract of sale of goods, so wherein we have certain principles wherein sale of goods when we deal, so those applies. Though there is a separate sale of goods act also, there is separate partnership act also. So when you are drafting a particular agreement from the point of view of partnership, say partnership deed, so you have to keep into mind the principles of the contract law also, and the principles enshrined under the Partnership Act 1932 also. And when we go into the sale of goods, so you need to take into account there are many principles which you should be aware of under the Sales of Goods Act. So that being said, let us move forward that how to draft an agreement or a contract, which I may say so, because any agreement enforceable at law becomes a contract. So agreement is the starting point of the contract. We must look into the definition given by under section 2E of the Contract Act, which defines an agreement as an exchange or promises between two or more parties. For making an agreement, following 5 things are required. Firstly, there must be 2 parties, at least 2 parties must be there. There can be more than 2 parties, but there must be at least 2 parties. One of the parties invites other to make an offer. Invited offerer has the option either to accept the offer or reject the offer. When an offer is accepted, it becomes a promise. But that promise has to be consensus ad idem, that is meeting of mind. Parties have to show in their document that they have agreed on a particular thing and they both understand what are the practical implications of that, because there cannot be any agreement where one party perceives a particular thing in a different manner and the other party perceives a thing in a different manner. So consensus ad idem is an important thing. Then there is an important element, that is intention to create legal relations. that is presumed in commercial transaction whenever we enter into any sale of goods act, sale of goods agreement or any partnership deed. So obviously it's a commercial thing, and we presume that the document is being entered into with the intention to create legal relations. So if it's a mere out of love and affection, that agreement is not enforceable at law, because that will not become a contract, right? So right now what we are trying to understand is that how an agreement comes into picture. So we have discussed these 5 things. Let us move ahead. There are other things. Now we come to a stage where we are discussing how an agreement will get transferred into a contract, which is a legally recognized document before the courts of law, and the parties are bound by the contract. So section 2H of the Contract Act may be looked into, which says that agreement enforceable by law becomes a contract. In other words, contract is an enforceable agreement. So our topic of agreements, different types of agreements. So it is nothing but a contract which is enforceable agreement. So we are looking at the agreements which are enforceable in nature. An agreement which is not enforceable, there is no point in entering into such an agreement. So those agreements will remain an agreement simpliciter and cannot be acted upon, cannot be enforced in a court of law. So when we can say that an agreement has become a contract, we can say that when we say the parties who have entered into the contract, they have entered by way of free consent, that is, which is not caused by coercion. Coercion means violence or threat thereof to the body or property of other party or his relatives, or undue influence, that is, there are certain number of times wherein one of the parties is at such a dominant position that it can dictate the will of the other. So that is called undue influence. So we have to be very, very clear that the agreement portrays, when the agreement is being signed by the parties, that there is no undue influence. Similarly, there is no misrepresentation. That is, statements which are not true, but they are made by the one party and the other party relies on those statements and enter into the contract. So tomorrow, the party can say, this is not a valid contract because it was misrepresentation. So similarly, there is another point which says contractual capacity. If the parties are not contractually capable of entering into a contract, so then they cannot enter into a contract. For example, minor, unsound mind, a person who is disqualified by law, they cannot enter into the contract. So while drafting the agreements, while reviewing the agreements, you have to see whether an agreement is being entered into by minor. If that is so you must look into that aspect. Similarly, you must look into that the agreement is having free consent. So there are various ways in which, while drafting an agreement, while reviewing the agreement, while writing the agreement, you can look into and say that this agreement is being entered into without any undue influence, misrepresentation, and the parties have agreed, they have gone through the document and they are fully satisfied, they have understood the terms and conditions. So by this way, you give an assurance and remove the possibility of challenging it on the ground that it was the consent was not free, right? So let us go ahead. Then there should be lawful consideration. An agreement without consideration cannot become a contract, because there has to be consideration. Sufficiency of consideration is not important. An act may be done for rupees 500. An act may be done same act may be done by another person for 5 lakh rupees. Sufficiency is not being looked into. However, where the sufficiency of the consideration is such a wide discretion that where the courts may look into that there was something, that is when we say, we have discussed, you must have learned in your company that lifting of the corporate veil, that if a particular things at the prima facie level looks X, but if you lift the veil, there is a Y. So there is a kind of lifting of a veil. So that way, if the consideration is grossly insufficient, then it can become a point of contention that the contract is not there. It is not a valid contract. Right? Then the object of the contract, the parties who are entering into agreement, there cannot be an agreement where you do an unlawful thing. So any agreement which is entered into to do something unlawful, so that cannot be in contract, because this is the basic principle. Then agreement may not be expressly prohibited. You have to see that, because there are certain laws in our country which expressly prohibit that you cannot do this a particular thing. So the parties need to ensure that under the garb of an agreement, you cannot get something signed which a law prohibits. In any case, if the parties enter into such contract, such agreement, that agreement will not be enforceable at law, because the party who is being affected can challenge it in the court of law that it cannot be enforced, right? So these are the basic principles which you must keep into mind while drafting or reviewing any kind of agreement. Let us move ahead. There can be different modes of making these agreements, right? When we are making a partnership deed, when we are making a power of attorney, when we are making a memorandum of understanding. So there can be various ways of making those agreements. We have just now discussed about the essentials of the contract, essentials of a valid contract. But this valid contract can come into picture through different methods. First method, which is very, very popular, is known as negotiated mode of contract, which is called consensus ad idem, wherein the parties negotiate and then come to a contract. So, for example, contracts may be made in a variety of different situations, like making queries, sale on service basis, buying goods displayed in show of windows, etc., etc. Then there is an invitation to make an offer. Like we just discussed a brief while ago, that firstly there should be an offer, then there should be an acceptance to that offer. But there are certain number of times the mode of creating that offer is somewhat different. For example, tender. Government sometimes come out with tenders wherein they are not making an offer. They are inviting the other side to make an offer, and when the other side submits the tenders, complete the tender, that is submits the bids, then those bids, those tender documents submitted by the parties are an offer. Then the other side will have to accept those tender to make it a contract. So tender notices, auction notices, price catalog, when we go to a restaurant, so there is an agreement. It's not an agreement when there is a menu, price list item is there. So the restaurant owner is inviting you to make an offer what you want to have. Once you give them an offer that I want to have this thing, so consideration is there and other things are there. So then the other party accepts that invitation to the offer, and it becomes a proposal. And thereafter, following the process of that agreement to contract, we go ahead, right? So then there is a self-contained contract. This is a contract which is based on negotiations, and all the contractual terms are included in that document. It becomes a comprehensive document. When we say comprehensive document, it means that what are the remedies in case of default, what will happen to a particular circumstance if this is not done by one party, because there can be reciprocal promises. You must have understood in your contract lessons when you have appeared in your executive or the professional development courses in the company secretary's course. So there can be different kinds of promises made by one party and another party, which is called reciprocal promises. Sometimes X has to do something, then Y has to do something. Sometimes Y have to do first, then X has to do something. So these are called reciprocal promises. But be that as it may, there is a self-contained contract in which all the terms and conditions are put into, and that is a comprehensive document. This kind of method is adopted when there is a very high value contract and the number of parties who are responding to the invitation are very small. So the basic features are one-pager document or two-pager document, whatever the page may be. It is a very concise document, but comprehensive in the sense it contains all the implications. Then it does not, this kind of contract does not need to make any reference to another document. Each clause is self-sufficient in itself, complete in all respects. So this is the another way of entering into a contract, which we just discussed is self-contained contract, SCC. Then there is GCC and SCC. GCC means general conditions of contract and SCC means special conditions of contract. These kinds of contracts are made when there are big construction contracts are there. There's a works contract which is given by an employer to the contractor to perform the works, like in highway contracts, in various infrastructure contracts which we generally see. There is a tender notice is there, then all these things happen. So tender documents incorporate general conditions of the contract. General conditions of contract are usually included in a contract. These set the minimum performance requirement for the contractor and sets out the rights and responsibilities of the parties. So these general conditions of contract, if we just go into detail, so it governs the entire contract, entire period of the contract, and contain contractual principles which are applicable to most of the projects which may go in that big project. So it specifies schedule of quantities, it provides specifications of work, it provides drawings, it provides any other document. So all the nuances are discussed in the general conditions of contract. So then there comes a special conditions of contract. This is also the part of a main contract. So these are to be read in conjunction with the general conditions of the contract. So special conditions of the contract, in other words SCC, these special conditions are specific to one contract, and more technically, if I may say so, they are more in relation to the operational in nature, how particular things have to be executed. This gives further nuances of the general conditions of the contract. So they may not be as deep as GCC because they will be specific to a particular thing and they will be providing how that particular thing has to be done, whereas the GCC will define the overall scope and responsibilities, right? So we have discussed the tender. There are general rules. Tender may be for a specific offer, like government comes out with a tender. They say for supply of certain, fans in the government department, there is a tender. So all the fan companies who want to sell their fans, they can give their tender documents. So the fan companies who will give the tender bids and all, so they will be making an offer, and those offers will be a specific offer if the tender relates to particular quantity. If the tender is a standing tender, so the offer will be made in a standing offer. When I say standing offer, it means that while the offer is accepted by the government, by the fan making company, but during the period of time, there will be the orders which will be placed by the government, and each specific order needs to be accepted by the government. So in principle, approval is given to the standing offer, and in case of specific offer, it pertains to a particular lot, particular period of time, and then it is accepted. So these are the basic things which you should know while drafting the agreement, while reviewing the agreement, or when there is a dispute before a court of law. So company secretaries also act as in-house counsels. So company secretary in practice, they also work in various fields. They appear before the tribunals also. So they have to analyze these kind of documents. So these principles are very, very important. So these are practical things which you should keep in mind. So going further, we can make the classification of the contracts on the basis of initiation also. First is unilateral contract. That is, it is nothing but a contract wherein one party says, if anybody informs a person that he is there, we'll give him a reward. So this is unilateral. That is, that person has given a particular offer, and anybody who performs acts on that offer, that is, it accepts it. So that is a contract where there is no negotiated thing. So bilateral contract is a contract which involves mutual exchange of promises between two or more parties, such as buyers and sellers. Then we can divide the agreements or contracts as we can use the term synonym. When I say agreement, kindly remember, agreement has to be enforceable at law. So when I use contract, that also means the agreement. We will be using the term interchangeably, right? So on the basis of formation, the contracts or agreements can be express contract, there can be an implied contract, there can be a quasi contract. When we say express contract, it means that word spoken or written. When a contract is entered, what we have discussed earlier, mutual, all these things, those mutual things, if they are expressly said, then it becomes an express contract, and if they are implied from the conduct or circumstances, then it becomes an implied contract, right? Then there is a quasi contract. That is, certain number of times a party does something for the other party, and the other party takes the benefit of that party, the work done by the other party, and gets enriched in terms of money, in terms of goods. So then law imposes in equity, justice and good conscience that the person who has taken the services or who has taken the goods, though there was no contract, and if he has used those goods or used those services, availed those services, he must pay at least a reasonable amount. So that is a bone of contention. So generally when there is a express agreement, and after the conclusion of the express agreement, if still there is some work done by one party, so that party can claim on the basis of equity. It is not that the contract has come to an end and that party will have no right. Then on the basis of enforceability, because these express contract or implied contract, which we have just discussed the principles a short while ago, that if it is not backed by consideration, if it is entered by minor, so that agreement may become a void agreement. So similarly, that if all the terms and conditions are being complied, terms and conditions, when I say the terms and conditions which are governing the contract are complied with the Contract Act, so then that is a valid contract. And certain number of time there is a voidable contract, that is agreement enforceable at the option of one or more of the parties, but not at the option of others. Supposing you have done something, the other party doesn't wish to enter into a contract, so then they can say that I don't want, so they can, or they may do something and they say that we will have a voidable option with us, So contract becomes voidable due to absence of free consent. So suppose you make an agreement which is a contract and the consent is not free, so then that contract cannot be enforced at law if the other party who is aggrieved is saying that my consent was not free. So there will be an option before that party whether to accept that contract and go on, or it may say that this contract is not valid. So it's unvoidable. It is at the option of that party. Similarly, on a party being prevented from performance may opt to repudiate the same. Like there may be a party which, due to the other party's breach, may not be able to perform. So then the party who is being the sufferer because of the other's non-performance may not perform his part, because then that contract will be a voidable thing, because he can say that the party X was to perform before me, he has not performed, so I repudiate the contract and I make the contract voidable. So having discussed all these things, let us quickly go through the other important parts which we can just have. Void agreements we have just now discussed, where the agreements have unlawful object or consideration which is forbidden by law. For example, under the Hindus, you cannot have more than one wife. So if you contract with someone to have someone as a wife, so that cannot be done because the law doesn't allow. Similarly, there can be something which is immoral in the eyes of law in the particular customs in India. There may be certain things which are not allowed, so they are against the public policy. However, there is no definition of public policy precisely. It will keep on changing with the experience or exigencies of the time, So then agreements opposed to public policy are also like that. If you do an agreement with a country or a person or a corporate with who is in a country in which the country is in a mode of war, that is, it is an enemy country, so any kind of contract entered into with such country will not have any valid sanctity. They will be void agreement. So there are certain void agreement which are expressly declared void, like agreement without consideration, section 25 of the Contract Act says it is a void. Then agreement with unlawful object, section 23. Then there is agreement by incompetent persons such as minors, etc. So disqualified by law, this is section 11. So there are certain agreements which are per se void. I am just discussing these things because if someone is trying to enter into an agreement, so you should be aware of, or you are trying to bargain something, so there should be clarity in the mind that a agreement which is void ab initio, that is from the starting, you cannot enter into such a agreement or a contract even if the other party is willing to do anything. So an agreement which is declared non-performable, non-enterable by law itself, so you cannot do it, So then agreements in restraint of marriage, you cannot enter into an agreement with someone saying that you will not enter into the marriage, you will not marry at all if I give you this much of amount, or if I agree to give you this thing, you will not enter into. So similarly, agreements in restraint of trade, requiring a person not to engage in a lawful business, profession, occupation, trade, employment of any kind. This is again an per se void agreement, that is section 27 of the Contract Act says that. However, there are exceptions to it also. We will not be going too much into detail. We come to very important doctrine of severance, which is part of the contract drafting. Supposingly one party has entered into a contract with another, and there are certain terms which hit the Contract Act, which are void or which cannot be performed. So whether the whole of the agreement will be not enforceable at law, that it will not be considered as a contract at all, or only certain portions of the contract will go. So on this, Supreme Court and other courts have given interpretation. They have said that the court may divide the contract so as to enforce the valid portion and annul the illegal part. So for example, if there is a single illegal consideration for one object, the entire contract will be void because the consideration is for the whole contract. So then you cannot bifurcate. So it is the section 24 of the Contract Act says it is void in total. Similarly, in case of reciprocal promises where one party has to do and the another party has to do certain things legal, so there are certain things which are legal, certain things are illegal. So the legal things can be separated. If it can be separated, so then that contract will remain, the other part will not remain. So going by these things, similarly there can be contract in terms of absolute contract, that is where the contracting parties must perform their promises and there is no option, that is they don't have to wait for certain contingency, unseen, unforeseen event. If they have to wait for an unforeseen event to do a particular act to perform their part, so that becomes a contingent contract. So insurance contract, indemnity contracts, guarantee contracts, these are all contracts in the realm of contingency contract, and they are also called conditional contract because they are based on a condition that if a certain event which is uncertain, it will happen, so then only it will be performed. And in case that uncertain event it doesn't happen or it becomes unlawful later on, because there can be certain agreement clauses wherein certain raw material has to be imported from another country, and that country enters into a war with Indian country. So then it is impossible, because we cannot, it is against the public policy, so that clause cannot be enforced. So in such situation, those contingent contracts may become void. So all these things you have to plan accordingly. So you have to go through the legal provisions. So these are very important provisions which are practical in nature. If you are not aware of that, tomorrow the agreement may end up in a court of law, and the party you are representing, or you yourself are a party, then you will find yourself in a vulnerable situation. So going ahead, what are the important points one should keep in mind while drafting agreements or deed? So let us first understand, you may have heard about partnership deed, lease deed, and other kinds of deed or agreement. So we have seen wherein we see technical nature of things is given in the heading of the contract, the deed itself. So what is that? Deed in legal sense means a solemn act denoting document, and it may be defined as an instrument written on a paper, executed, signed, sealed, and delivered by the executant. So document, if sometimes you will come across the word document, sometimes you will come across the word deed. So deed is a legal sense. You are solemnly saying that this is a document which has been signed, which has been agreed, and it has been executed before a notary, which we'll discuss later on what is that. But for the time being, kindly concentrate that it's a document which shows that there is a binding nature of a particular thing. So then there are documents. Documents means any matter expressed or described upon any substance by means of letters, figures, marks. So then which can be taken cognizance by the court of law or tribunals. So those documents become document. It is not each and every document. Any document which can be taken cognizance before a court of law, that is signed or a letter or a different thing. So these are the definitions, legal definitions, which are looked into by court of law. So then there are certain components of a deed which you will find everywhere. First, while drafting the deed, you have to see what is the law which is involved between the parties. Supposing you are drafting a lease deed, you have to take into account the Transfer of Property Act. If you are drafting a partnership deed, you have to look into the Partnership Act. So Partnership Act, for example, there is a provision, section 59, if I'm remembering correctly. So that talks about effects of non-registration, because if the partnership firm is not registered, so then the partnership firm cannot sue, and it will have unlimited liability and other things, other consequences entail. So then you have to keep into mind the law of that particular thing which the parties want to govern themselves. Similarly, limited liability partnership. So similarly, there can be a power of attorney. So you need to be you need to look into the Power of Attorney Act. So similarly, whatever document you are drafting, all the main laws and the incidental laws which will have bearing on that contract, you have to look into that. Then you have to look into the effect of the transaction, how it will affect. So you have to keep into mind the practical aspects of that contract law which we have discussed. Apart from that, you have to always look into the other specific areas of the law. So majorly, when you see an agreement or a deed, so there is a sequence which happens. First sequence is description, name, title of the deed. That is partnership deed, lease deed. So, and then there is a line which starts all deeds, this deed of mortgage, this deed of sale, this lease, blah blah. So whatever you are entering into, you have to define it that this deed of mortgage or this deed of sale says so and so. When the deed is of complex nature, then you can say this deed says so and so. So first part is the description of the deed. You have to give the heading to that document, and then you have to describe what is that deed all about. Then you have to put in the date and place. That is, you say this lease made on the first day of February 2021. So this is the way where you ensure that when this agreement or the deed will come into execution. So then you have to define the parties. So there can be two. Obviously, for any kind of agreement, there will be two parties. There can be more than two parties. So you have to describe them. After the dates, there will be name and description of the parties. That is, you have to describe all those parties who are necessary and proper parties. When I say necessary, necessary means which are the parties who are privy to the transaction or privy to the business or privy to the object between which the parties are intending to enter into a contract. And there can be certain proper parties which though may not be directly related to that contract, but they have some bearing. That is, there may be a bank which may be involved. So you can put into depending upon the requirements and depending upon the law which is involved in that particular transaction. So full description of the parties is generally given to prove the identity, because tomorrow if the contract goes into a court of law, then you have to identify this is the particular person with whom the contract was entered. Because if, for example, if somebody says agreement entered between Mr. Mohan and Radhesham, I'm just using the fictitious name. This has got nothing to do with any particular person identity. Any kind of similarity is just a by chance. So when you describe Mr. Radhesham may say, I'm not a Radhesham, I'm somebody else. So you describe them in the form that Mr. Radhesham, son of so-and-so, residence of so-and-so, tehsil number, if it is some village, or if it's a city, then you identify with the name of the city, name of the district, etc. The more nomenclature you give, the better it is. But obviously, it should not be too technical in nature that you have to prove, because certain number of times you have to come with a proof, identity proof. So it should be similar to that identity proof, what I'm into. Then there comes a technical word, recitals, that the agreement must have recitals. Recitals can be divided into two parts. First is the recital, you give a background, that why you are entering into this particular agreement. So that is called a narrative recital. Then there is an introductory recital, wherein you explain the motive motive of the preparation of that particular deed or the agreement. That is, when you are entering into a partnership, you say that the parties, Mr. A, Mr. B, and Mr. C, they have decided to carry on a particular business, and for that purpose, they want to streamline the conduct of the partnership business and other things. So we are agreeing to certain terms and conditions. So these are given under this partnership deed. So these are the motives. So then there is a testatum. It's a technical term. Testatum means that is, you give an authenticity to a document, because under the Transfer of Property Act, Section 3, we'll come to it this in detail a little later, which talks about clearly that there must be at least 2 witnesses to a document. So when we say there should be 2 witnesses to a document for attestation purposes, so you give in the agreement or the deed itself, now this deed witnesses as follows. So this way you are saying that the witnesses have witnessed this deed, whatever is being given, and when they sign, they read over and all these things. So then another part is the consideration. As we have just now discussed, without consideration there cannot be an agreement, contract, that is agreement to be enforceable at law, must have consideration. Similarly, according to the Stamp Act also, consideration should be fully and truly set forth in the deed, because on the basis of the consideration, the stamp duty is being assessed. Then comes the covenants and the undertakings. These are basically the contractual clauses wherein the parties give to themselves that what are the roles and responsibilities, what are the indemnifications. Supposing some party says, okay, you are giving these kind of representation that you have the authority to sell this product, the product is free from defect, you are giving and in case there is defect in your representation, you indemnify me. So any kind of arrangement, because as we discussed initially, parties can agree amongst themselves any kind of clauses, however it should not violate the law. So that is the concern. Then in case there is a dispute, what will happen, what will be the dispute resolution clause? Parties can agree among themselves that particular court of law. For example, Mr. X and Mr. Y enter into a commercial agreement, and then they say in case of a dispute, the Delhi courts will have jurisdiction, though the parties may be living in Gurgaon or Noida. So if they agree in their document that the Delhi courts will have exclusive jurisdiction only, so then the Delhi courts will have jurisdiction. Otherwise, the Code of Civil Procedure will be governed by the in terms of the jurisdiction of the courts. Similarly, the dispute resolution clause can talk about alternative mode of dispute resolution. That is, in case of dispute, we will not go to court. What we'll do is that we will go to arbitration, or before going to arbitration, first we will try to conciliate, negotiate, or mediate. Then we'll go to arbitration. So any kind of thing can be done. These all are coming under the covenants and the undertakings, right? So let us go further ahead. Then when covenants are being said, so there is a technical term, like if one party is only giving certain assurances, like in the indemnity bond or selling a particular property, the vendor may have to declare certain things. So the vendor hereby covenants with the purchaser as follows. But where the agreement contains parties who are mutually agreeing upon certain things, so then it can be said that the parties hereby mutually agree with each other as follows. Then you can describe n number of clauses, whatsoever you want to describe: role, responsibilities, indemnity, dispute resolution, what will be the consequences of a breach of the contract, liquidated damages. Unliquidated damages are being calculated by court only. Liquidated damages, you can put in a clause that in case of a breach, the other party will have to pay one party this much amount. Dispute resolution, we have already discussed. So all these clauses go. Then there is testimonium, which says that the in witness whereof the parties hereto have hereunto set their respective hands and seals the day and year first above written. So it says that we are testifying that on this particular day we are agreeing to this document and we are signing, and thereafter there is signatures of both the parties and there is an attestation by 2 witnesses at least, right? So these are the certain important things which any kind of agreement you are looking into, you have to take into account all these things into account. So obviously we are not going into the particular partnership deed or limited liability partnership. It relates to all kinds of agreements. So another topic, subtopic which we will touch briefly is memorandum of undertakings. So friends, let me just tell you that memorandum of understanding is nothing. It's a nomenclature of an agreement. So whatever principles we have discussed right now, so those will be applicable to the memorandum of undertaking also, when you want to make memorandum of understanding a binding document. If you do not want to make memorandum of understanding a binding document, which happens in several cases, because what happens is that whenever there is a big project and the parties do not wish to have a binding agreement at the first date, so after the meeting they may want to zero down certain documents. So then this document comes into picture, wherein they put into their understandings what the parties have understood and put their hands that we have understood, and there will be a legal binding agreement which will be entered later on based on this MOU. That is, it will be the basis because we have discussed certain general broad terms and conditions. So you cannot enforce such MOUs. But apart from that, nomenclature of an MOU, if it is given, that doesn't mean that every time it will be a non-binding. There, if the MOU satisfies the conditions of the contract law, binding agreement enforceable at law, that is, it is made between the major parties, consideration is there, and there is an intention to create legal relationship, lawful object is there, and the parties have given, the wordings are like that, the parties shall do this, and it should be done in this much period of time, these are the roles and responsibilities, rather than wording it a commercial agreement, they have worded the term as memorandum of understanding, so that will not take away the binding nature. So kindly mark a difference. So these kind of MOUs are also entered between universities, sometimes it is like on a voluntary basis that we will, on a best friends relationship, we will do this. But when the parties show in that document that they want to have a legal binding relationship, then that MOU also become an agreement enforceable at law, and it becomes a contract. So having said that, so we just come to a very, very important judgment of the Supreme Court of India, which was in the state of Orissa and others, versus Titagar Paper Mills Company Limited and another, in which Honorable Supreme Court has let down that it is true that the nomenclature and description given to a contract are not determinative of the real nature of the document or the transaction thereunder. That is, if you term a document as a MOU, and you cannot say that it is not binding in nature, if otherwise, in real sense, if lifting the veil, you can see that there is a binding document. So all the conditions of the Contract Act, to be very, very precise, that is section 10, which we have just now discussed, if that are satisfied, then the court will not merely say it is a MOU, it is not binding agreement. So then the nomenclature will not have any role to play. These, however, have to be determined from all the terms and MOU clause of the document and all the rights and results flowing therefrom, and not by picking and choosing certain clauses. So you cannot just pick and choose 3-4 clauses and say, see, these clauses are very, very simple, broad in nature, so then that's why this is an MOU which is not intended to be acted upon. But since this is just worded at MOU, so this is not a binding document. So court says it is not that picking up 2-3 clauses will help you. The court, if the document, if that comes to dispute and it goes to a court of law, then the court will ascertain the document, it will go through all the clauses, and it will look into the fact that whether the intention was to create legal relationship, whether other terms and conditions of the Contract Act was justified. If that was so, then the matter ends. Then the nomenclature MOU, Memorandum of Understanding, will not make it anything different than a contract, right? So we have now discussed Memorandum of Understanding also. Now coming to the other part of the topic, that is affidavits. Affidavits, when we discuss affidavits, law relating to affidavits is given under section 139 of the Code of Civil Procedure and order 19 of the Code of Civil Procedure. So we'll come to section 139 later, because 139 talks about who can administer oath for the purposes of affidavit, right? It relates to an oath on affidavit, by whom it can be administered. So we'll come to that later on. But what we should discuss is that order 19 of the CPC relating to affidavits, because it gives the court the power to order at any point of time, if it is of sufficient reason believed that any particular fact or facts may be proved by affidavit, or affidavit of any witness may be read at the hearing on such conditions as the court thinks reasonable. So then the court can order that party to give the evidence on affidavit. However, where it appears to the court that either party bona fidely desires the production of the witness for the purposes of cross-examination, then, and the witness can be produced also, it is available, it can come to the court, then the court may say that affidavit in evidence will not be admitted, because we will want that witness to come for cross-examination, not on the basis of the affidavit you will cross-examine, right? So then there is a court's power to order attendance of the deponent. Deponent means the person who is affirming, who is giving on oath certain things, so that is called deponent. So upon an application, when a certain person makes an application before a court of law, that evidence may be given by way of affidavit, but the court may, at the instance of either party, order the attendance for cross-examination of the deponent. So court has got wide powers. So having said that, what are the matters to which affidavit shall be confined? This is very, very important. Affidavit shall be confined to such facts as the deponent is able to prove on his own knowledge. So what is important, that deponent should state all those facts which he can prove through his own knowledge. If he cannot prove through his own knowledge, he should not state it. However, in the case of interlocutory application, that is any application which is filed once a court suit or a petition or a case once begins formally, then any kind of application is being filed and it is supported by an affidavit, because affidavit is basically governing, assuring before a court of law that whatever is being said is said truth, and in case it is not truth, there are consequences of perjury, that is falsification being said before a court of law, which is sacrosanct. So there are legal consequences which are there. So a deponent who is giving an affidavit, he has to state those facts which is in his own knowledge. However, in case of applications, statements can be given which are believed by the deponents and which are on the basis of the information received by someone else. However, then the deponent has to give in that affidavit what are the grounds, what are the reasons on the basis of which he believes certain facts, certain statements which he is giving on the affidavit. Then now we discuss what is the format and guidelines of affidavit of evidence. So affidavit should be confined to and should follow chronological sequence of the dates and events that are relevant. So friends, what we need to follow is that there should be chronological sequence. What? Dates and events. Dates and event, the first date, the first event which has happened at first stage should be given first, and then it should be followed by the subsequent event, right? And those facts, those evidence which are being given in the affidavit, they should be relevant for proving any fact or any matter dealt with, right? Then second point is that where the court is of the view that the affidavit is mere reproduction of the pleadings. Sometimes the parties, what they do is that while they are giving evidence, they just reiterate what they have stated in their pleadings. So we'll come to in detail what are the pleadings, but for the timing, just remember whatever documents is being filed by the parties in a court of law, that are pleadings. We'll come to technical nature, what is plaint, what is written statement, what are other things. But for right now, you can understand that if a party, while giving evidence on affidavit, if it states all the things whatever he has stated in the pleadings, so then the court has the power to strike out such parts which are repetitive in nature. Then right now we have just now discussed that there should be separate dates and events, but that should be divided into the paragraphs. It should not be in one paragraph you sum up all the things. It should be separate paragraph. As much as possible, distinct portion should be allotted to each para. Just not for the sake of dividing a paragraph. If you are particularly stating a particular evidence or a particular fact which is continuation in nature, you should not break it down to another paragraph. That should be in one paragraph. But the moment there is a separate event, separate fact, separate evidence, you should give it in a chronological manner according to the date and event it has happened in a separate paragraph. Then we come to the affidavit. Shall state which of the statements are made from deponent's own knowledge and which are matters of information or belief. Just now we discussed, if there are certain paragraphs which a deponent has stated out of his information or belief from some document or from some other person or some other thing, so then he has to give the source also in that this information which I am deposing in the affidavit, it is from this source, because this is based on an information. When it is on the basis of his knowledge, then he can state as it is, then no source is required, because this will help for the purposes of cross-examination. The other party, if the person is saying on his own knowledge, so they can cross-check on that own knowledge and they can just see whether the truth is being said in affidavit or not, and it helps the court in determining what whether a fact has been proved or not proved. So then an affidavit should be drawn up in the first person. Then another important guideline is that you should state the description, occupation, if any, and true place of residence of the deponent at the very first place. That is, I so and so, son of, daughter of so and so, residence of so and so, solemnly affirm hereunder. And then whatever pages are there of affidavit are there, they have to be numbered consecutively as a separate document. And we have already discussed, it has to be divided into paragraphs, all numbers, dates should be expressed in figures also and in words also. Then if any of the documents are being referred into the body of the document and they are annexed also, or any other pleadings, then give the annexures and page numbers of such document that are relied upon. Every affidavit shall be instituted in some cause, appeal, or the matter. That is, in the court of so-and-so, in the matter of so-and-so, because an affidavit cannot be filed as such in a court of law that this is my affidavit. It has to be in a particular cause, appeal, or a matter. And it has to be shown that the affidavit is being sworn under that cause, appeal, or matter. Right? Then, now this is important, which we are talking about section 139 of the CPC. Affidavits for the purposes of cause, appeal, or matter may be sworn before notary or any authority mentioned in section 139 of the Code of Civil Procedure, or before the registrar of the court, because Delhi High Court rules, procedural rules, they provide that affidavit can be sworn before notary. And now this becomes important. What is notary? What is oath commissioner? We'll talk about it in detail a little later. That is the next topic. But for the right now, just kindly understand that the affidavits have to be sworn. It has to be sworn before certain persons. Those certain persons can be notary or any authority mentioned under section 139, or it can be the registrar of the court, or it can be before the commissioner, generally or specially authorized in that behalf by the court. So authority which will be attesting any such affidavit where the person is known to him, kindly note, where the person is known to the attesting authority, then the attesting authority has to append a certificate saying that I know this person. Then if the affidavit is being attested by the attesting authority, when that attesting authority is not known to the deponent, then the certificate shall state the name of the person by whom the person affirming the affidavit has been identified. So somebody has to identify, yes, I identify this person and he is making the affidavit, he has to sign. And that identification, because the affidavit authority who is attesting the affidavit, they have to note down in the register also all the details, who has identified, who is the person who is swearing the affidavit, and what is the relationship between the person who is swearing the affidavit and the person who is identifying the affidavit. And wherever an affidavit is affirmed by an illiterate or a person who is not conversant to the English language, then the authority, that is the attesting authority, shall, before attesting this same, they should translate and interpret the contents of the affidavit to the person affirming the same, that is deponent, and certify. He has to write that it has been interpreted and told to the person who is making the affidavit, and signature is to be given separately. Similarly, where the deponent, the person who is giving the affirmation, the deponent is a Pardanashi lady, that is, unless she is known to the person attesting the affidavit, then first she has to be identified by a person who she is known to, and that person has then also to prove the identification by a separate affidavit. He has to give a separate affidavit that this Pardanashi lady, because the affidavit attesting authority, they cannot see that Pardanashi lady. So the person who is identifying, he or she has also to give an affidavit that I know that person. So then every exhibit which is annexed to an affidavit has to be marked, initialed, and dated by the authority before whom it is sworn. Right? One needs to know that affidavit is exempted from the court fees. And under section 139B of the Code of Civil Procedure, 2 to 4 legal practitioners at the headquarters of each district and 1 at each station where there is a subordinate judge, they are appointed as oath commissioner for the purposes of administering oath and affirmations with the previous approval of the High Court. So what is the difference between notary and oath commissioner will come a little later. So right now, I think you should be aware of what are the contents of the affidavit, what does the affidavit means, how it has to be drawn up, right? So now we come to the further subtopic which talks about notary and oath commissioner. So when we talk about notary and oath commissioner, firstly, you have to keep in mind, notary public is appointed by Government of India or by the state government under the Indian Notaries Act and the rules made thereunder. Similarly, there is an oath commissioner. A commissioner of oath is commonly known as oath commissioner. An oath commissioner is appointed by the chief justice of the state for discharging functions in a particular city or state. So first difference is it is appointed by government, it is appointed by court. Notaries, what is the purpose of notary? Notaries authenticate documents which are required by the public for day-to-day life. So basically the purpose of notarization is to give effect that the attestation, that is the witnesses have signed properly and the document is a legally binding document between the parties, the contract which has been entered between the parties, because sometimes they may say I have not signed it, so I have not signed it, he has just, so when it has been notarized, so it is an evidence that the signature of the parties and the attesting witnesses who are there, so it gives a certainty, it gives an authentication to the document. For example, deeds, property, power of attorney, all these needs to be notarized. However, oath commissioner, notaries can also notarize the documents which can be used before a court of law. However, oath commissioner can only do such documents which have to be produced before court of law. So notary have a wider role to play. Oath commissioner role is a little narrow. It is confined to the court proceedings, court documents. And oath commissioner is empowered to attest only those affidavits which are to be submitted in courts in judicial or quasi-judicial proceedings. And oath commissioner is only empowered to attest affidavits of deponents by bestowing an oath on them. So in the name of God, or there are different kinds of oaths which are given. Sometimes parties are of religious mind, so there can be a religious oath. It can be in the name of God. So we are not going into that detail. What I am trying to differentiate between the notary and oath commissioner is notary has got a wider role. It can also attest an affidavit which it can be submitted to a court of law, but oath commissioner is only allowed to attest those documents which has to be submitted before a court of law. A notary is authorized to certify as true copies of the original after comparing the said copies with the original. So this is very important differentiation between the notary and an oath commissioner. That is, notary has been authorized to certify that a particular document is a true copy of the original, but he has to certify a particular photocopy. Say for example, there is an original document and there needs to be certain more copies of that, and the party to whom those copies are given, they want to have an authenticity, so it can be notarized. So the notary will say this document is a true copy of the original, and it will give a stamp onto it and say it is a true copy. When it says true copy, that means he has looked into the original document, and that is why he is certified, and that is why this document will have more credibility, authentication. So that's why people notarize those documents. An oath commissioner, however, is not empowered to attest copies of document as true copies, because his role is to give oath, affidavit on oath, and the documents have to be submitted before a court of law. So that is the very important. So these are the main differences between a notary public and an oath commissioner. Now we come to our another topic, that is attestations. Attestations, friends, firstly, one should keep in mind Section 3 of the Transfer of Property Act, which defines attested in relation to an instrument. Instrument means any document, which means and shall be deemed always to have meant attested by two or more witnesses. So what important point is that whenever there is a document, kindly make sure that it is being attested by two or more witnesses. Minimum of two, maximum can go more than two obviously, but it should not be less than two. Each of whom, that is the witnesses who are attesting, each of whom has seen the executant, that is the person who is executing that document, he is signing and affixing his mark to the instrument. So what attestation means that the two persons who are witnesses, a document is said to be attested when those witnesses has seen the executant sign or affix his mark to the instrument, or it is an alternative, has seen some other person sign the instrument in the presence and by the direction of the executant. So executant may sign, or anybody else on his behalf, on his direction, may sign in his presence. Then, or has received from the executant a personal acknowledgement of a signature or mark, or of the signature of such other person. So if these conditions are satisfied, then a document is said to have been properly attested. So, and firstly, we have talked about there should be two witnesses for attestation. Second, we have seen each witness must see the executant or the other person, or must have received an acknowledgement of a signature. Then and is there in the definition, and each of whom, that is witnesses, they have signed the instrument in the presence of executant. But it shall not be necessary that more than one of such witnesses shall have been present at the same time. It is not necessary that both the witnesses should be present at the same time while attesting. However, each witness has to sign in the presence of the executant. Similarly is the case for the executant, that he has to sign in the presence of the witnesses, or he can delegate it to some other person, but he has to be there under his direction, that person has to sign. And there is no form of attestation which is there, no particular form of attestation shall be necessary. So they have just to, then there is a stamp of a notary that this has been attested. So having discussed this thing, so what are the essentials of a valid attestation? We can break up into 8-9 points. These are: attesting witnesses must always be two or more for it to be an authentic attestation. Second, attester should, though need not see the execution of the legal instrument, he must either see the executant sign or affix his mark, or see anyone else do so on the direction of the executant, or receive personal acknowledgement from the executant of the same. But it is mandatory for the attestator to sign or affix his mark in the presence of the executant. When I say attestator, it means the witness who are attesting. They have to sign or affix their mark in the presence of the executant for it to validate as an attesting witness. The attester can only sign after the execution of the legal instrument document is complete for it to be valid attestation. They cannot sign prior. Attestators, that is the attesting witness, two or more, need not sign or affix their mark at the same time. This is also we have discussed. There is no particular form of attestation that the parties need to adhere to. Even a signature by an attesting witness at the legal document with all form and formality may constitute attestation. He doesn't have to write in lengthy language. So once he has signed as an attesting witness, so there is an, but the thing is that it is assumed that it is any more attestation, that is an attestation with the intention to attest. It is not for the purpose. Supposing somebody says, okay, you sign this just for the purposes that you have received the copy. It is not for the receiving the copy. It is with the intention to sign as a witness and as an attesting witness, and whatever we have discussed right now, that he should see the executant signing and then he should sign. So all these steps have been given just to make it a thorough thing, so that tomorrow no party can say that we have not signed it, or this was signed in our absentia, or this is signed just for the sake of some other purpose. So everything is clear. So then the court gives very valid sanctity to all these kind of things. So we now come to another topic, that is power of attorney. This is very, very important topic. Where you will come across these kind of document very often in your commercial parlance, because at many a times a person is not able to execute certain documents, so he gives power of attorney to some other person. It is basically a principal and agent relationship, wherein the principal gives the power to the agent to do certain acts and get bound by those acts done by the agent on his behalf. So power of attorney is a document of agency basically, or you can say it's a formal arrangement by which one person, that is principal, gives another person, attorney or agent, an authority to act on his behalf and in his name. So it shows to the outside world that I am giving the authority to Mr. X, so Mr. X can do any of the acts within those authority, and I will be bound by the acts done by Mr. X as if I have done those acts personally. So, but there is a distinction. There is, in the commercial parlance, there are two types of power of attorney. First is general power of attorney. Another nomenclature given is special power of attorney. We must look into very, very briefly what is that. But before that, let us look at the definition given by the power of attorney as per the Power of Attorney Act 1882. Power of Attorney Act 1882 defines power of attorney to include any instrument empowering. So there should be a document, that is instrument, which empowers, that is which gives powers to a specified person. It cannot be given to many people. It can be given to a specified person to act for and in the name of the person executing it. That is the person who is executing the power of attorney. Suppose Mr. X is executing a power of attorney, so then, and giving it to A, Mr. A. So then Mr. A will is a specified person who will act for and in the name of Mr. X, who is executing the power of attorney. So that power of attorney can be a general power of attorney or can be a special power of attorney. General power of attorney covers more than one subject matter, and special power of attorney, it covers a special, or we can say specific subject matter, though it may contain several powers relating to the same subject matter. For example, Mr. X may give Mr. A general power of attorney to do all the acts relating to a business, his business. But when Mr. X gives power of attorney to Mr. A for selling a property, just a particular property, and gives him many rights, that is for the purposes of giving it on rent, or for the purposes of selling the property, or for signing any other document, if he gives him all those powers, then also it's a special power of attorney, because it relates to a specific subject matter, it relates to a specific property, and for that property he is giving all the rights, so it becomes a special power of attorney. When he gives power for all the things relating to the business, including property and running the business, signing the checks, etc., etc., so then it becomes a general power of attorney. Let us briefly have a look at how the power of attorney looks like. Power of attorney is required to be stamped but need not mandatorily be registered, because you must have read in your company secretary codes that there are certain documents which are compulsorily registrable and there are certain documents which are not compulsorily registrable. So power of attorney is not compulsorily registrable, but stamp duty has to be paid on the power of attorney. So generally this is how a general power of attorney looks like. Know all men by these presents that this general power of attorney is executed at New Delhi or Gurgaon or whatever the place, wherever the place of executing, on this first day of February 2021 by Mr. So-and-so or Messrs. So-and-so or company incorporated under the Companies Act through its managing director, if it is a company, or if it is a person, then it says Mr. So-and-so, son of so-and-so, as we have discussed just a short while ago. Then it says that to institute, commence and conduct any action, suit or other legal proceedings before any court, arbitrator, quasi-judicial or authorities, offices, tribunal, labor courts, conciliation officers, land acquisition officer. So in respect of any matter connected with or arising out of company's business and subject to aforesaid to settle, adjust, compromise or submit to arbitration any such action, suits or proceedings. Second, to defend all actions, suits, proceedings, etc., etc. in the name of the company. To appear and represent the company in the court, justice or tribunal whatsoever and for the purpose aforesaid. To sign any document, wakalatnama, to revoke any appointment. So all these powers are given to continue and conduct or defend any appeal, review, revision, writ, generally for and in the name and as the act and deed of the company to make, execute, and do all and every such further act and other act. So this way, it is giving a general power of attorney to do all the acts. So generally, as a company secretary, if you are working in a company, so these kind of power of attorneys are generally given in favor of the company secretaries who are officers of the company. So these kind of documents you will come across in your company role also, and when you are a practicing company secretary or you are doing any other thing. So these kind of power of attorney will come into these will come into your knowledge every time. So then there is a special power of attorney in which it says that, for example, to receive from the purchaser or his heirs or assigns the sum of rupees so and so, being the price agreed to be paid to me by so and so for the purchase of property. You have to give the description of the property, to execute a proper sale deed of the aforesaid property, the property name which is given. So when this type of power of attorney is being made, this is being made with the intention to tell that subject matter of the property is located at this place, and then the power of attorney describes in detail what the person to whom this authority is given, what he can do. So he can do only things in relation to that specific property and not in relation to all the things which that person may have. A person may have more than one property. So if a power of attorney is given in respect of property number 1, so he cannot execute certain things for property number 2 just because he's having authority for property number 1. So it is specific to property number 1. So it's a special power of attorney. So whatever is given in that power of attorney, what he can do, he will be able to do only those things. So contents of the power of attorney are very, very important. Even in the case of general power of attorney, it doesn't mean that he can do n amount of things. Whatever clauses are given under the power of attorney, it is only those clauses will define the scope and ambit of the authority, what can be exercised by that agent on whom that power of attorney is being bestowed with. So having discussed that, let us come to our final topic, subtopic, that is difference between petitions, applications, writ petition, rejoinder, and pleadings. Just to briefly distinguish between all these things, a petition is a term which is used in special statutes like Companies Act, Competition Act, other acts, Debt Recovery Tribunal Act, wherein there is no plaint or suit is involved. We'll come to it a little later, what is that suit. But just for the sake of understanding, kindly remember, anything which is not a suit, which is not a plaint, is a petition. When a particular cause of action arises under a particular law and you have to file a particular cause before a court of law or before a tribunal, then that particular cause, the paper book, is called petition. Then there are applications. Applications, anything, once a suit, once a case has been started, or once a petition has been filed in a court of law or before a tribunal, any kind of application which is filed before a court of law, it becomes the interlocutory application, which means an application to the court in any suit, appeal, or proceeding already instituted in such court other than a proceeding for execution of a decree or order, because proceedings for execution of a decree or order are altogether in a separate proceeding. So that is a petition in itself. So that cannot be termed as an application. So any kind of application which is filed in a suit, appeal, proceeding, or petition, then it becomes an interlocutory application, and any order passed by a court of law on that application becomes an interlocutory order. Right? So once an action has been commenced, all the subsequent applications are referred to as interlocutory application. So friends, we should remember that whenever interlocutory applications are filed before a court of law or tribunals, so applications are to be disposed of first before disposing of the main suit, appeal, review, petition, etc. That application has to be disposed of by the court of law or the tribunal. But while dealing with that application, there are certain principles which the court take into account. First principle is that the courts or the tribunal, they do not delve into serious questions of law which demand detailed argument and serious consideration, because that is the subject matter of the suit or the petition itself. They do not go into the facts, the resolution of which might end up in the determination of the original suit, because under the garb of the application, you cannot take the relief which is to be given after appreciating the evidence, after listening to the arguments the court has to go into. The provision dealing with the incidental proceedings is contained under Part 3 of the CPC. So there can be an application for appointment of commissioner, there can be an application for temporary injunction under Order 39. So there can be different applications, if I may say so. There are more than or around 382 different nomenclature of interlocutory application as provided by the Honorable Supreme Court's website. So these kind of applications can be filed, but of late, on the recommendation of the Law Commission also and various Supreme Court judgments also, there has been one section 35A, if I remember correctly, on the Code of Civil Procedure, where cost can be imposed if you are just filing the application for the sake of filing, or in the garb of the application you want to delay the proceedings, because obviously we all know that our system is an adversarial system. One party, when files an application, it has to be served on the other side. Other party also is given the opportunity to file their reply, and the arguments are being heard. It takes time. So if parties try to adopt delay tactics by filing applications which are not required in a court of law, which after perusal by the court they come to the conclusion they are not fit, they are just filed by way of frivolous applications, so then sanctions can be imposed against, and heavy costs are being imposed by various court of law. So having said that, we come to our another topic of writ petition writ petition, friends, you must be aware of our constitution. Constitution have different articles, schedules, etc. So there are two articles which are very, very important, which touch upon the jurisdiction of the Supreme Court and High Court in relation to the writ petitions. So one is Article 32, which relates to Supreme Court, and one relates to Article 226, which relates to High Court. So there are few differences in the writ jurisdiction of these two courts, because the Article 32 gives the power to the Supreme Court to have the writ jurisdiction, and Article 226 gives the power to the High Courts to exercise the writ jurisdiction. What are the writs? What are the differences between the writ jurisdiction? We'll now discuss that. First is, there are 5 types of different writs, jurisdictions, writ petitions which can be filed by anyone. Which is, first is habeas corpus, second is mandamus, third is prohibition, fourth is certiorari, and fifth is quo warranto. So before we discuss the differences between the writ jurisdiction of the Supreme Court under Article 32 and writ jurisdiction of the High Courts under Article 226, let us briefly touch upon what these different 5 types of writs mean. First is habeas corpus. Habeas corpus means you shall have the body. It basically relates to the detention of someone if a person has been illegally detained. So this writ petition can be filed by way of writ petition of the nature of habeas corpus before High Court or the Supreme Court. The purpose is to seek relief from unlawful or illegal detention of the person by himself or herself or by another person. Because if the person is illegally detained by any authority, then or any person, then that person may not be able to approach the court. Then in such a scenario, any person on that person's behalf can approach to the High Court or the Supreme Court by way of the writ of habeas corpus, and thereupon the court will try to protect the individual from harming himself or herself, or by the administrative system. There may be any illegal detention by the police authority or by any other enforcement directorate. So then these can be filed by those person himself, herself, or by any other person. This is basically for the purposes of safeguarding individual freedom against the arbitrary state action generally, which violates fundamental rights, more particularly Article 19, freedom of speech and expression, Article 21, right to life and liberty. Those are the main things. So then person detained or their surrounding members can file the writ, and then the person can then the Supreme Court or the High Court can ask the authorities to produce the body of that person, and then ask whether the detention is legal or illegal. If the detention is illegal, then the person is to be set free then and there. So this is the writ of habeas corpus. So generally the writ jurisdictions are invoked against the state, which are defined under Article 12. Article 12 talks about state, which can be central government, state government, or any local authority. Even authority may not be exactly as government authority. Then also if it partakes the character of a public nature, then the courts have held that it is a state, and they have granted relief against those authorities. So then another thing which we need to discuss under the writ jurisdiction is the writ of mandamus. Writ of mandamus is a court's order commanding the lower court, tribunal, or a public authority to perform an official duty correctly. So friends, what we'll need to look into that, the first habeas corpus writ was in relation to producing the body of a person to ascertain whether the person was detained legally or illegally. If the person has been detained illegally, then the person has to be set free. The writ of mandamus talks about the official duty which has to be performed by the lower court, tribunal, or the public authority, and if they are failing in their duty, then an order by the court in the nature of a mandamus writ, which is an order commanding to lower court or the tribunal to perform its duty properly. If a public authority is not performing their duty at all, then the court can order them to do that. It means that we command, do that. So then the writ can be granted against the public authority if generally these are the points which are generally argued before a court of law, that is the High Court or the Supreme Court under their writ jurisdiction, that the public authority has acted against the law, or the public authority has exceeded its limits of power, or has acted with malafide, or did not apply its mind while giving a particular decision or an order. And it can also be on the ground of that the public authority has abused its discretionary powers, because discretion has to be a sound discretion. It has to be a reasoned order. If there is no reasoned order, so it is all the more gives an implication that the discretion was not exercised properly, or the public authority did not take into account relevant consideration, or has taken into account irrelevant consideration. If you do not take into account the consideration which has to be taken, that is the relevant things which have to be taken into account while giving a decision, if you do not take that into account, then you are not deciding properly. Mandamus writ can be issued. If you are deciding on a particular material which is totally irrelevant, then also it is wrong. Mandamus can be issued. Then there is a writ of prohibition. Writ of prohibition is generally given. It is a type of, it is to forbid or to stop. It is called a stop order. It is issued in cases where there is an excess of jurisdiction and where there is absence of jurisdiction. Like if the courts or a public authority can do a particular thing up to a level, while exercising their jurisdiction, they exceed those jurisdiction. That is the jurisdiction which was never there before a court of law, lower court, or by a public authority or an administrative authority. Then that authority can be stayed. That is the excess authority can be stayed, or where there is no authority at all. If a public authority cannot exercise a particular jurisdiction and it is entertaining, it is giving a decision on that jurisdiction, then that jurisdiction can be stopped by way of writ of prohibition. Then there is a writ of certiorari. It is issued by the Supreme Court and High Courts for quashing the order. That is an order which has been passed by a public authority or a inferior court, that is lower court, tribunal, quasi-judicial authority. Then they can quash that order. That is, this kind of writ is issued by the Supreme Court or High Court to correct the errors of jurisdiction when the court or tribunal acts illegal in its jurisdiction or against the principles of natural justice. You must have heard about principles of natural justice. Two major parts of principles of natural justice: right of being heard and right of notice and opportunity of being heard. That is, if you do not give a party a hearing, that is, you do not give them the chance of representing their case, so then it is bound to be flawed, and then these kind of writs can be issued. So there is a maxim called nemo judex in causa sua. Nobody can be judged in his own case. So these are the various principles. You may have learned it. We are not going into that detail because that is not within the scope of our today's lecture. So that is the thing. Then there is another writ that is writ by way of quo warranto. Quo warranto means what is your authority. So there can be certain times a person who enters or holds a public office which he or she may not have entered into because of violation of certain provisions of a statute itself. Like for example, for becoming for the purposes of fighting elections in a Lok Sabha, then you have to have certain age. For fighting elections in Rajya Sabha, you have to have a particular age. If you are not of that particular age and you have fought the election and you have won the elections also, then also that elections can then that post which that person has entered into, that can be quo warranto by the court by saying that that post cannot be held. So these are the basic type of writs. We now come to the subtle differences which are there between the powers of the Supreme Court and High Court under 32 and 226, Article 226, because both the courts have power to issue these kind of writs. But what is the difference we need to understand as a matter of practical significance when we can approach High Court, when we can go to Supreme Court, what can be done, what they can grant the relief, what they cannot, when they cannot grant the relief. These are certain important things. Firstly, Article 32 empowers the Supreme Court to grant writ. Then Article 226 grants power to the High Courts. So Supreme Court is only one. High Court is there in each of the states, mostly each of the states, and certain states or the union territories have High Courts. So we are not going into that detail. What we need to understand is that each state can have writ jurisdiction, where the High Court always have a writ jurisdiction. So Supreme Court is one, and obviously Supreme Court has writ jurisdiction under Article 32. Then another difference is that Article 32 is more restricted. It is restricted in the sense it is invoked only for the enforcement of fundamental rights, whereas Article 226 gives power to the High Courts to enforce other rights as well. So it has got wider application. So similar kind of writ can be given by both Supreme Court and High Court, but Supreme Court will give the writ only when there is an infringement of the fundamental rights. And it is very important to know that even Article 32 is also a fundamental right, and which is generally called constitutional remedy, right of constitutional remedy. Then another thing is that power to issue writs given to the Supreme Court is mandatory in nature, that if the fundamental rights have been breached, so court generally exercises that power. Whereas in case of the High Court, because since it has got wide powers to enforce legal rights also by way of writ jurisdiction, so there is a discretionary remedy is there. When we say discretionary remedy, over a period of time, courts have evolved the principle that while interpreting Article 226 of the Constitution, the courts have imposed on themselves a self-imposed restriction. That is, if there is an alternative efficacious remedy available, High Court generally do not grant writs. They say go and avail the remedy which is available to you, which may be in the form of normal forums following the hierarchy of the courts, depending upon the amount, the jurisdiction, subject matter jurisdiction, etc., etc. Or there can be certain remedy available under special statutes, so you have to go to NCLT. So you may go to NCLT, do not come to High Court directly, they say. So these kind of discretionary remedy, they have imposed self-restrictions on themselves by the High Courts under Article 226. Then, as we discussed right now, that Article 32 in itself is a fundamental right, whereas Article 226 is a constitutional right, because any right which is given to a particular person through a constitution, it becomes a constitutional right. But whereas under the constitution itself, if there is a fundamental right, though the fundamental right is overall within the scope of the constitutional right, but it has got a special nomenclature of fundamental right, because due to this special thing, so there are certain special privileges which a citizen and certain point of time non-citizen gets, which cannot be made available to a non-fundamental right, that is constitutional right. So this Article 32 can be suspended during the emergency, where the fundamental rights are suspended certain number of times. So then Article 226 cannot be suspended even during the emergency. This is a right which is sacrosanct. It cannot be suspended even in the time of the emergency also. An order given under Article 32 supersedes an order given under Article 226. That is, if an order under 226 is given and then there is an Article 232 order, so it supersedes. This article, that is Article 32, has greater territorial jurisdiction, because the Supreme Court, once it passes an order, it can pass order by way of a writ. It can issue the writ in any part of the country. However, under Article 226, High Court of a particular state has the territorial jurisdiction. It cannot cross those territorial jurisdiction. If the writ has to have an impact outside the territorial jurisdiction, then the territorial jurisdiction of a state where the impact will be, that has to be seen, and accordingly jurisdiction has to be invoked. Now we come to the rejoinder. Once a writ petition has been filed by a particular person, the other side has the right to file a counter affidavit. That is, it is in itself, it's a kind of a reply. In technical word, it can be said that it's a counter affidavit. And when counter affidavit is filed by the other side, the person who has filed the writ petition itself in the first place, he may at time ask the court for a rejoinder, that is a reply to the counter affidavit, when there are certain clarifications which are to be given, because there are certain issues which are raised in the counter affidavit which needs reply. So then the writ petitioner, that is the person who has filed the writ, he is given the right to file the rejoinder affidavit. So rejoinder affidavit in a writ petition is the response by the petitioner to the counter affidavit filed by the respondent. Rejoinder affidavit may include response to the new facts raised through the counter affidavit filed by the respondent. This is what I have discussed right now. Rejoinder is often known as reply to the counter filed by the opposite party, that is the respondent. So this brings us to the more or less the last topic, that is pleadings. So friends, before we discuss what is pleadings, in a very broad sense, we can say that pleading is the beginning stage of a lawsuit in which parties formally submit their claims and defenses. So pleadings comprises of respective contentions of the parties in a dispute, which are reduced into writing. Because when you go to a court of law, a person files a suit, other party has to be given a right to file his defense. Whatever is reduced into writing, whatever the claims and defenses are put forward by the persons, that is the claimant and the other person respondent, so then those becomes the pleadings. In civil proceedings, when suit is there, because when we say pleadings, when we come to word suit, there are two parties, one is plaintiff and another is defendant. In civil proceeding, plaintiff submits a plaint, that is stating the cause of action. Cause of action means the issues in controversy. The defendant thereafter submits an answer, that is the reply. It is called written statement, stating his or her defenses and denials. In other words, pleadings are nothing but formal presentations of claims and defenses by parties in a lawsuit. Therefore, it includes every legal document filed in a lawsuit: petition, motion, hearing, complaint, answer, reply, rejoinder, motion, anything you call by any name. When you combine all of them together, these are known as pleadings, right? Then let us try to understand. The term pleading would be applicable to the court proceedings, including filing of a complaint, plaint, replies, other incidental documents related to the dispute filed by either of the parties. So all these things together becomes pleadings. So in a suit, because this is a technical word, suit, petition, we have discussed petition at the first place under special statutes, and anything which is not a suit is a petition. So in a suit, as defined under Order 6, Rule 1 of the Code of Civil Procedure, pleading means plain or written statement. If we go by Code of Civil Procedure, and in relation to a suit, when we talk about, it merely says it means plaint, that is plaintiff, when he files a case in a court of law, it is known as plaint. And when the defendant, the other side, when he files his reply, which is called written statement, this plaint plus written statement becomes pleading, right? What is plaint and what is written statement in technical language, if I may say so? Plaint means a statement of claims called as plaint, in which plaintiff sets out his cause of action with all necessary particulars, narrating all the facts which are the basis of claiming his particular case. Written statement is a statement of defenses. It is called written statement, in which the defendant deals with every material facts alleged by the plaintiff in the plaint, and also gives any new facts also which tell story in his favor, adding such objection as he wishes. So that is called written statement. Then often at times there is asked, is there any other kind of pleadings also? Generally, these are only the pleadings as per Order 6, Rule 1 of the CPC, that is plaint and written statement. However, as a matter of right, there is only one more pleading which is called subsequent pleading, which is there, which doesn't require leave of the court, because filing the plaint and filing the written statement is the party's right. Any other pleading which has to be filed in a court of law has to have the leave of the court, that is only after the permission of the court is given. But there is one more pleading apart from plaint and written statement which can be filed as a matter of right, which is called a written statement of a plaintiff. When defendant in his written statement puts some new defenses or new facts of which reply needs to be given by the plaintiff, then plaintiff as a matter of right can file a written statement. Like the defendant says that Mr. X in his plaint has asked for 5 lakh rupees that he wishes to recover from me. Mr. Y says in his written statement that I also have to take 7 lakh rupees from Mr. X. So in effect, I have to take 2 lakh at the best case scenario. But obviously, the parties generally do not admit it, but they say that I also have a set of claims. So when one party says I also have to have the recovery, then the first party needs to reply by saying, denying or saying some other facts. So this is known as subsequent pleading. So sometimes there is an additional pleading also. This is generally done when the court wants to have some additional written statement. For example, these are pleadings by way of further and better statement of the nature of the claim or defense, or further better particular things. So it often is called replication. The subsequent pleading, that is this written statement, in some states is also termed as written statement, which in England we have followed the common law system also. There it used to be called reply by the plaintiff. So when there is a clarification by the plaintiff to the written statement of the defendant, so it will become a replication. So it may be allowed by the court as by way of a additional pleading. So having discussed that, one should always remember what is the object of the pleading. Object of the pleading is that it is for the, first of all, it is for the benefit of the parties, that each party knows the case of another party, what he has to make, right? Like Mr. X says that I have a claim against Mr. Y, so Mr. Y should know what Mr. X is claiming. In the absence of pleadings, Mr. Y will not be able to answer that why he is not liable to pay Mr. X, or why Mr. X is making a false claim, or whatever may be the reason. So it gives the benefit to the parties to know exactly what are the matters in dispute exactly. So another point is that it makes the judge clear that what are the issues involved which have to be decided by the court on the basis of the evidence and the arguments of the parties. So there are certain fundamental rules of the pleading while drafting the pleadings which should be there. As a company secretary also, since you will be able to appear before tribunals and various regulatory authorities where similar rules of CPC, though not strictly applicable, but similar to that apply. So first fundamental rule is that every pleading must state facts and not law. So in the pleadings, you have to state facts. You don't have to state law, because law has to be interpreted and applied by a court of law, a judge. However, there may be certain cases where in pleadings you may have to write facts which are law related facts. Like somebody may say that the suit is not maintainable because of limitation. So limitation is a law. Question of law, and certain question may be a mixed question of law in fact, where you cannot tell whether a particular thing is out of limitation or not, so you have to state those things. So certain things may not be facts but may be law, but it has to be very minimal and only when it is required, right? So there may be certain requirement like under section 80 of the Code of Civil Procedure, while in filing a suit against a government or a statutory authority, you have to give them a notice under a particular format. So that format has been given, you have served a notice, then you write in your petition you write in your pleadings that section 80 notice has been complied with, though it's a statement of law, but it needs to be stated. So these are certain other things, but more or less you have to state facts only. Then the pleadings must state all material facts and material facts only, because facts are also of many kinds. There may be material facts, there may be other facts which are supporting facts, but you need to tell material facts. So the second fundamental rule of pleading is that every pleading shall contain only a statement of material facts of which the party pleading relies for his claim. So any fact which is the basis for the claim or defense must be stated, and because it's a material fact. The facts which are essential to the plaintiff's cause of action or defendant cause of action becomes a material fact. So in other words, we have just now discussed the facts which are essential to cause of action are material facts. Similarly, in other words, we can say that a fact is material for the pleading of a party which is bound to prove at the trial, unless admitted by other party. So what the facts which you have to prove to bring home your case before a court of law, all those facts become material facts. However, at certain point of time, you may need to describe certain things like how this particular fact has come into picture. So you may need to refer to some document that you can refer to, but not reproducing whole of the document, because then it will not be statement of material fact, it will be statement of other facts also. So another thing, it must state only the facts on which the parties pleading relied and not the evidence. So another important rule is that while giving the material facts, you should not give the evidence in your pleadings. When you have to give the evidence, it is a separate stage in the trial. While giving pleadings before a court of law in the form of a plaint or a written statement, parties need to set out the cause of action, whatever things they have to prove. They may not give the details how that fact will be proved. That will be a separate stage. Another important rule is that the pleading must state facts concisely but with precision and certainty. Obviously, the facts may not be given in a haphazard manner, so obviously it has to be given with precision, certainty, and concisely. That is, you do not have to give a plaint with 1000 page. So obviously, it may run into 1000 page if the cause of action material facts are so much, but ideally it doesn't go into that fashion. So material facts must be stated in a summary form and must be written very succinctly and in a strict chronological order. The facts which are appearing at first place should be given firstly. The facts which are coming into the second place should come secondly. The third place should come thirdly. All unnecessary allegations and their details should be omitted in order to attain the brevity of the pleadings. Sometimes a party may have to write a particular fact again in a subsequent paragraph to support a particular claim. So he may do with very, very brevity by stating that these had been said in above and are not repeated here for the sake of brevity. Because unnecessary allegations, unnecessarily putting the facts will make the courts deviate from the main issues, and the parties will not be able to disclose their case of law, their case before a court of law properly, and the court will not be able to do justice and come to the issues, main issues. So that is the way. Another point is that pleading is not a place to show your fine writing. It is nothing but assertion of hard facts. What you are claiming, it should facts supporting those claims should be given. It is desirable. It is always desirable to go straight to the point and state facts boldly. Boldly, when I say, in the sense, in a matter of saying, not bolding it, unbolding it. It is by way of saying that it should be clearly said. It should be concisely said to avoid all paraphrasing and all duplication. As far as possible, an active voice should be preferred to the passive voice while drafting the pleading. The same person or things should be called by same name throughout the pleading. For example, when the plaint is being written, when the pleadings, the main cause title is there, the memo of party is there. Memo of party means when the petitioner, who is the petitioner, you define and you write he is the petitioner. When the petitioner is writing, or the plaintiff is writing, when you have written plaintiff, defendant is Mr. Y and Mr. X is the plaintiff. So you need not write Mr. X, Mr. Y, you need not write his full name. You can write plaintiff, you can write defendant. Plaintiff says that defendant has not performed, defendant has not paid. So in spite of using the name or the name of the company, who is the plaintiff or defendant, as the case may be, you have to use the nomenclature which is being defined in the memo of the parties. So you have to go by that. The pleading shall be divided into the paragraph which are numbered consecutively. So dates, sums and numbers shall be expressed in figures also and words also. Even though pleading should be concise, it should never be obscure. It should be concise as well as precise. The parties cannot change the case and get the relief. So this is in totality the main cuts of what we have dealt with. And there are certain other important things also, like there may be certain custom and usage of any trade and business which needs to be pleaded. Then you need to plead those also if a party wants to rely on them. Similarly, there is if the facts of negligence is there, right or liability, unlawful or wrongful act, which party is saying, they have to be specifically pleaded. Every plea of the fact should be specifically raised and then it needs to be specifically proved. Similarly, a certain number of times nowadays we have got many economic legislations in which there is very high reliance on the foreign case laws also, so foreign laws also. So the parties may wish to put it, though it's a pleading should not have law, but since foreign law is not automatically the thing with the judicial notice is being taken, so then the status of that foreign law has to be, if it is to be relied upon, it has to be set forth as substantially as like any other fact. So I think with this we are done with our session on today's topic, practical examples of basic legal documents containing agreements, memo of understandings, affidavits, difference between notary and oath commissioner, attestation, power of attorney, difference between petition, application, writ petition, joinder and pleadings. I hope all of you must have enjoyed this session, and thank you very much. And I thank ICSI for giving me this opportunity for discussing the legal skills for the company secretary students who are in the process of passing out or have passed out. So I wish them all the best for their future endeavors. Thank you very much.